HB826.
Thank you, Madam Chair, members of the committee. I'm going to say something that you don't hear very often in this building, and that is that occasionally I like to be wrong, because when I'm wrong, that gives me an opportunity, and that opportunity is to learn something. I don't think in 7 years as a legislator there's ever been a bill that I had that was opposed by the Commonwealth Attorneys Association. There is today, and the reason that there is, I think, is because I was wrong. And so I ask your indulgence as we discuss HB826 on asset forfeiture. In Deuteronomy, it says, and I will paraphrase, probably mispronounced the book of the Bible as well, that the sins of the fathers will be visited upon the children. Currently, our assets forfeiture does that and more. It is a system run amok. As the members of this committee are quite well aware, there are different standards for different types of offenses within our criminal justice and civil court system. There's a preponderance of the evidence, more likely than not, and there's a beyond a reasonable doubt, and these are standards that we hold people to in civil cases versus in criminal cases. But in civil asset forfeiture, your civil standard tends to bleed in to criminal cases. I'll give you an anecdotal story which is 100% true. A woman in Virginia, small business owner, is charged with the first offense of possession of marijuana with intent to distribute. Not crack cocaine, not methamphetamines, marijuana. She's not Pablo Escobar. The Commonwealth, in this case, attaches everything she owns: her home, her car, her businesses. Now, this does a lot of things. It places an onus upon her to make decisions that impact not just her, but also her children. Right? Because if everything she owns is tied up in civil asset forfeiture, and the standard that the Commonwealth must prove in order to take these things from her and her posterity is more likely than not, then rolling the dice may mean that your kids don't inherit anything. Her business, her home, her car, about $800,000 for first offense possession of marijuana with intent to distribute. It really has the effect of denying her constitutional right to counsel, or at least to choose counsel, because she's run into a circumstance where she can't afford the counsel that the work that she's done, and perhaps the circumstance she found herself in prior to this offense would have afforded her, because her assets are tied up. What this bill does is ties the amount that the Commonwealth can forfeit to the amount of fines attached to the criminal offenses with which a defendant is charged. That means for a class 1 or 2 or 3 or 4 felony, it's $100,000 per count. That's real money. But you wouldn't be able to tie $750,000, this woman's entire life savings and fortune for everything that she'd done since she was a child, plus what she'd inherited from her parents, plus her business that she built with a partner, up on a first offense possession of marijuana with intent to distribute. What we have in the current status quo is coercion. It's blackmail, and it applies a civil standard to a criminal proceeding that causes defendants to make decisions that the founders who gave us our Bill of Rights didn't anticipate them having to make. And so while I was a prosecutor and while I have utilized asset forfeiture to the fullest extent of the law, looking back and having spent some time as a defense attorney, it occurs to me that perhaps this law needs to be relooked. And so as such, I ask you to set aside any prejudice that you might have about me, about my party, about what you think that bills that I'm going to carry or be like, and ask yourself what serves the ends of justice, what serves the women and men of the Commonwealth, what's in the best interest of ensuring that the sins of the fathers are not visited upon the children, wherein those children might be innocent. And with that, I would yield to any questions or any other individuals hoping to speak on the bill.
Delegate Williams.
Question for the patron.
Please.
Delegate Garrett, I do have a question with regard to what this bill doesn't do. And it feels like you bring up a point about a young lady risking a lot of money because of her intent to distribute marijuana. But I'd like to ask you about the cartel and others in our communities that have millions of dollars worth of cash and assets that have been gained illegally. Do you think that their civil forfeiture would be limited to the highest fines and costs, which could be nowhere near the profits and revenue that they've generated?
So I would take exception to the structure of the question, Madam Chair, insofar as the lady in the question, the fact pattern has not been adjudicated guilty, but her assets have all been tied up. That's sort of the point, right? As it relates to the cartels, I'm not familiar with a case where the Commonwealth is trying the cartels. The cartels are comprised of individuals, and individuals should be subject to law, and justice that is not blind is, and you can quote me here, actually not justice. So I can't treat someone differently because their last name's different, the color of their skin's different, their religion's different, or because we think they're affiliated with the Sinaloa cartel. The law is the law, and it should be uniformly applied.
Madam Chair, follow up.
Hey, please.
So I'd like you to actually answer the question I asked, which is what would happen to the money after forfeiture, after they've been found guilty? Would it go back to their family members, or would it come to the coffers because of the money's been brought and made on illegal activity in our Commonwealth?
So the money never goes back to the family members, and it has nothing to do with an adjudication of guilt. That's the point. There's a civil burden here. So many times they seize assets and asset forfeiture, and then your client's acquitted. But since the standard, the burden here is preponderance of the evidence, the assets get kept. So I don't know how I'm not answering the question, but that's the injustice we seek to remedy. I don't have a problem with taking the ill-begotten gains of drug dealers. I do have a problem with taking everything that a woman has worked for her entire life, plus what her parents gave her, plus what she set aside to send her kids to college. So I don't know if I'm missing something here, and I'm not trying to be obtuse. Sometimes that just comes naturally to me. But I, again, would fall back on the idea that justice that isn't blind isn't justice, and we shouldn't be taking from our citizenry without due process. And frankly, the fact that we have two different standards where asset forfeiture is truly used as a cudgel and punishment, I think is inconsistent with the Bill of Rights and the Constitution.
Are there any other questions? Seeing none, do we have people in the audience speaking for the bill?
Thank you to the committee. My name is Zachary Worrell. I'm a member of the Virginia Bar. Speaking on behalf of the bill because civil asset forfeiture needs to be tied to the criminal standards and the foundational pillars of justice in this country. Now, I think Delegate Williams brought up an interesting point, and that is this bill isn't perfect. It doesn't do exactly what needs to be done, which would be impose the same exact standards on these proceedings as are due in the criminal proceedings for the individual. These processes are done in rem as opposed to in personam, and so you sidestep all of the constitutional issues that arise. However, Virginia has tried to do that repeatedly, and it has failed to happen repeatedly, and the definition of insanity, as Einstein once brilliantly said, is trying to do the same thing over and over again and expecting a different result. And I'd also like to point out that not all progress, or excuse me, all progress is incremental. And so while this bill might not perfectly address the underlying fundamental issues of civil asset forfeiture as they exist today in Virginia, what this bill does is it opens up another avenue to explore ways to rein in the abuses, which are evident because, again, they've done through function, or excuse me, they've done through form, avoided the due process problems while ignoring the effect that is the outcome. And so, you know, if you oppose this bill because it doesn't do it right, again, I ask that you consider moving it forward to try to achieve some incremental progress. And if you oppose the bill, for example, because law enforcement doesn't get funding, that they asked for, well, then I submit that maybe it ought to be in the budget. Thank you.
Thank you.
Thank you, Madam Chair. Once again, my name is Eugene Oliver. I'm a criminal defense attorney from Harrisonburg, Virginia. Speaking in my personal role, I've handled a number of asset forfeiture cases, and I think everything that's been said so far is pretty accurate in terms of the due process concerns, the concerns that go along with just the process in and of itself. But I do want to address a couple of Delegate Williams's questions regarding particularly drug dealing, because that is somewhere where the statutory scheme that currently in place would actually address those concerns. 18.2-248 is the drug distribution statute. Standard possession with intent to distribute a controlled substance, the maximum fine is $500,000. If it is an elevated PWID, as we would say in my line of work, due to the amount of drugs, then the maximum fine is $1 million. So this is not a situation where there's even a small cap on what the asset forfeiture would be. But I will tell you, a lot of times, in terms of my experiences have been where we have bigger issues is we have embezzlements, we have larcenies. The issues were sort of the traditional more white-collar crimes, as they say, in which it can disrupt an entire family situation, disrupt a person's ability to afford counsel. I've had embezzlement cases where every single asset that person has owned has been tied up, regardless of whether or not there's actual proof beyond a reasonable doubt that it's connected to the embezzlement. Certainly, this is an incremental reform, but I would ask the committee to report it. Thank you.
Thank you. Any other one person speaking in for? Is there a person speaking against? Persons.
Again, Clarissa Berry with the Virginia Association of Commonwealth Attorneys. I'm the Commonwealth Attorney in Madison County. There seems to be a little bit of procedural confusion, and maybe I'm the one that missed that. Currently, under current law, there can only be a forfeiture after a conviction. So there's no seizure of assets without, well, the seizure occurs, but the attachment to the Commonwealth doesn't occur until after the conviction. The current, I guess, sentencing policy is to limit fines. A lot of these cases involve folks who are indigent defendants. One of the reasonably foreseeable consequences is that we would end up with cases with high fines. That is not something that happens today. And that, quite frankly, concerns me because many of these folks, as I mentioned, are indigent. As mentioned and appropriately, the PWID is a $500,000 cap. However, grand larceny of firearms is a $2,500 maximum fine. I have personally prosecuted cases involving grand larceny of firearms, possession of firearm by a convicted felon, and it is over 20 firearms. And so in that case, the question becomes, what then happens to those firearms? Are those returned to the defendant when he can't have them or she can't have them? How is that going to be handled? One of the other questions is that when we have multiple defendants, how do you parcel it out? The idea behind a forfeiture action is that all of the important parties are brought to the same case before the court. However, in an individual defendant capacity where there's been a motion to sever all of the charges, how then could you determine, there's a scenario where if we were all in a conspiracy together, we could all be fined the amount of the seizure, but there's only but so much money to go around. And as a result, we would ask you to not vote this bill out, that it don't think that it does what the desire is, and that a lot of the safeguards that we are concerned about are already in the system. Thank you.
Thank you. Before proceeding, counsel, do you have any perspective that we should be aware of?
Madam Chair, thank you. So I was going to make the same point that Ms. Berry did, that there is a higher standard after 2020 than there was before, because Delegate Simon's bill passed that required the tying of a forfeiture to a conviction, and no property may be forfeited until a conviction is had against the owner of the property. Additionally, the way the bill is written does not, I think, do what Delegate Garrett, I think, is intending to do here, because it says that the seizure is tied to the fine imposed. And so those words mean the fine that is given that individual defendant, which is where the point that Ms. Berry made, which is a not ethical or bad CA, I would say to a defendant, you have to plead guilty and take a $100,000 fine because we want to forfeit your $100,000. So now you've cost them $200,000. So it is not tied to the maximum penalty. It is tied to the individual fine imposed by the court under the language that's in the statute right now.
Thank you. Any questions of counsel? Delegate Garrett, final word.
Right. So what they can do right now is seize the assets, right? And so maybe I misspoke, and if I did, I apologize, but I still think that's an injustice because you seize somebody's assets in their entirety and you restrict their ability to get the counsel of their choice. So I think one of the folks who spoke in favor of the bill, and I thank those who did, said that this is a step in the right direction. I agree. I would ask the committee to find it the same and report the bill. Thank you, Madam Chair.
Thank you. Before Delegate Williams? Before making a motion, my own observation as I look at all this, and I've heard several times, it's a work in progress. And it may well need, as I look at it, there are many aspects that need work in progress that we've heard from, but I mathematically look at it and say, how do you possibly apply that standard of the value of the property without being tied up tremendously in the assessed value of the property and determining it and whether it's after sale, before sale, procedurally, such a limit that says shall not exceed even by $1, just administratively presents a significant issue as well in a contentious situation. A vote is in order unless there are comments.
I move to pass by indefinitely, and I'd speak to that motion.
And yes, you may. Is there a second? Is there a second to pass by indefinitely?
Second.
We have 2 minutes on each side to pass by indefinitely.
Yes, ma'am. I'd like to pass by indefinitely because this bill does not do what it is alleged to be doing. There's nothing in this bill that speaks about due process. There's nothing in this bill that talks about reasonable doubt. There's nothing in this bill that does what has been presented other than completely eliminate civil forfeiture up to a certain amount of dollar bills. So I would ask that this bill be passed by indefinitely and that the delegate take some more time to do some more work on fixing civil asset forfeiture if that's what he's trying to do here today.
Thank you, Delegate Williams. Is there anyone wishing to speak against the motion to pass by indefinitely? If not, clerk, please open the roll. It's a recorded vote. Members, please cast your vote on passing by indefinitely. I'll close the roll. HB826 by a vote of 8-0 will pass by indefinitely.
Thank you, Madam Chair. Thank you,
Very
delegates. I appreciate y'all's help moving forward.
The next bill before